because I've already introduced her, and just let Amy Howe get started and talk about SCOTUS law and the Supreme Court.
And we're going to go until
10:15.
10:15. Okay, so I'm going to talk for a while, but then I think we found over the years that this is much more interesting if we then open it up and you guys can ask questions and we can have a discussion. So I'm going to talk a little bit about the blog and my background and then move on to the court more generally. I think of myself as an accidental journalist. I went to law school at Georgetown and then went to work as a sort of litigation worker bee up the street at a firm called Steptoe & Johnson, and worked there for 2 years and decided that practicing law at a big firm was not for me. And so I left to go and work with my husband, who just started his own solo Supreme Court practice, while I figured out what I did want to do. And after a couple of interesting cases, including Bush versus Gore, I decided that maybe working with him on Supreme Court litigation wasn't such a bad gig after all. And so I was doing that in November of 2002. I was 7 months pregnant, and we were renovating our house when my husband came to me and said, I've got this great idea. I think we should start a blog devoted to the Supreme Court. And my first question was, what's a blog? And then my second question was, why would we want to do an idiotic thing like that? I think we've got enough going on right now. But we started it in November of 2002, and we were sort of modeling ourselves on a blog called How Appealing, which I imagine most of you are also familiar with. It's a terrific blog that covers developments in the appellate world more generally. And we started it as really a business development tool for the firm rather than as some sort of great journalistic enterprise, because we thought if you're two people who did not clerk at the Supreme Court and you did not work at the Solicitor General's office, and which are two common traits for people who practice a lot at the Supreme Court, you need some sort of business advantage, and this is something we can do. We can start a blog that shows off how much we know about the Supreme Court, and we can use that to get cases. And it has turned out to be a complete fail as a business development model. We're not sure that we've gotten a single case at the Supreme Court as a result of the blog, but it has been a lot of fun. And over the years, we have sort of morphed into a public service function, partly because we think of it that way now, and partly by default. And so at first, it was just the two of us. We had our office manager, who was heading to law school in the fall, and we had a couple of interns from AU, but we were really operating as sort of a skeleton crew, and we weren't making any attempt to be comprehensive in our coverage of the court. We covered the major cases, and so this was 2002, sort of 2002 to 2005. It was kind of a slow period at the court. So we covered the major cases, we covered anything else that we thought might be interesting, and we covered our own cases obsessively. And so if you go back, a lot of it I think is difficult to find now on the internet, but if you go back and you see things like, we filed this brief today, and it's fabulous, and here are the 8 reasons why we're going to win in this case. And then over the years, we started to sort of ramp up our coverage a little bit. We were teaching in Supreme Court litigation clinics, and we had some of the students from those clinics take on cases and read the briefs and do a little synopsis before the oral argument, then read the transcript, do a report in the report based on the transcript, or go to oral argument if they were in town, and then when the decision came down to write something on the decision and when it met. And that's really the point at which I started to get involved as the editor, as somebody who read all of the posts before they went up. We have some real doozies of typos if you go way back on the blog, because people would just put up posts without running them by anyone. And so one day we got an email. One day we got an email from a lawyer named Roy Englert, who's sort of a stalwart of the group of lawyers who practice regularly before the court. And he said, you might want to take a look at the blog, because one of the interns has just put up a post in which he refers to the Church of the Ladder, Ladder, Day Saints. So there were a few typos, and the law students from Stanford and Harvard were good. They're smart kids, but they've never practiced law, and so we needed somebody to come along and say, this is not actually a sentence. But we have sort of what I think of as our first great leap forward for the blog in 2005, when we brought on Lyle Denniston. And I hope that all of you have read Lyle's posts I don't know how much you know about Lyle. Lyle just had his 84th birthday. He has been covering the court for over 50 years, so he's covered more than a quarter of all of the justices who have sat on the Supreme Court ever during that time. And so he's sort of a walking encyclopedia of the Supreme Court. And Lyle has had 2 retirement parties at the court. He worked for many years for the Boston Globe, and then he retired and he went to work for WBUR in Boston, and then he was going to retire again, and we snapped him up and he came on as our reporter. So he's sort of our boots on the ground at the court every single day. And he, both sort of in the sense of giving us the heads up of when something's going to happen at the court, because that's information that the Public Information Office gives to the reporters, and then we can put it up, as an editor's note, that today we're expecting the court to issue orders to announce what new cases, if any, they are going to review next term. He, just increased instantly both the quantity and the quality of our coverage. And so he covers all of the major cases, a lot of the cases that aren't quite so major, but that he thinks are interesting. And then he also looks ahead, and you can see this up in the top right-hand corner, at some of the cases that may be coming down the pike. And so Lyle has been covering all of the same-sex marriage challenges in the lower courts, knowing that eventually they're going to percolate back up and wind up at the Supreme Court, so that our readers can keep track of what's going on where and when. He's also got a fascination with the detainee cases, which have not actually been back at the court for several years, but if they do, Lyle is ready for it. And the other advantage, one of Lyle's many advantages, is that he came with a press pass, which is something that the blog still does not have. Lyle has a press pass for WBUR, for whom he files a couple of reports a year, and I think is just sort of generally grandfathered in under the exception for people who've been covering the court for more than 50 years. So we brought on Lyle, and that was probably the most important thing that has happened to the blog, period. And then we started to continue to increase our coverage, and so 2007 we started something called SCOTUS Wiki that has now been incorporated into the blog itself. That is basically an electronic archive. There is electronic filing at the Supreme Court for the roughly 80 cases that they review on the merits every year, but there's no electronic filing requirement for all of the briefs that precede that. And just to sort of give you a very quick refresher course in Supreme Court litigation, if you lose in the lower court and you want the Supreme Court to hear your case, you file what's known as a petition for certiorari, which is a document that tries to convince the court that your case should be one of the 80 cases that it hears every year. And so the court gets thousands of those. It takes roughly 80 of them, and then it has briefing on the merits, and oral argument issues a decision. And so the petitions for certiorari are not filed anywhere online. And so we have a law student who works for us roughly 20 hours a week, and one of her primary jobs is tracking down all of these petitions for certiorari, and we then create pages devoted to the cases that we think are likely candidates for Supreme Court review. And so people use those essentially as sort of an electronic archive that then you can have all of the material that you need for a case, and you don't have to carry around stacks of briefs. We also, on days that the court is expected to issue decisions, we have what's known as a live blog we used to use the Cover It Live software. Now we use something called Scribble Live that allows people to we have sort of a running conversation with our readers. And Lyle is in the press room. There are no electronic devices allowed in the courtroom. Lyle gets the decisions in the press room as they're issued, and then he comes and gets on the phone with me, and I type out the result. The court issued its decision in McCutcheon versus Federal Election Commission. The court struck down the aggregate limits on contributions to candidates for federal office, political parties, and political action committees. It was 5-4, and so on. And so that has the advantage. We have sort of a running conversation that I think it allows people to feel sort of a little bit interactive. During the run-up to the issuance of the decisions, we take questions and comments from readers. And then it has we really started it because it allows people to, follow us without having to refresh their browsers to find out what's going on as we have new information, and it keeps our site from crashing, which is a real concern on days that the court is issuing the really big decisions like healthcare or same-sex marriage. Our second big leap forward, if you look in the top right-hand corner, was when Bloomberg Law agreed to sponsor us, and that allowed us to further professionalize the blog. I would be embarrassed to figure out how much we had been paying Lyle on an hourly basis. Before that, it was probably somewhere around minimum wage because he worked so hard. So it allowed us to pay Lyle something close, at least approaching what he is actually worth. We have 2 other staff members, usually young, recent college graduates who may be thinking about going to law school, although after working with us, many of them decide not to go to law school. I'm not sure whether that's a good thing or a bad thing these days. And then it has become my full-time job. I had been sort of working almost exclusively as the editor of the blog for several years, but in August, I left the firm officially and just to focus on the blog, partly because that's what I wanted to be doing, and also to further our efforts to get a press pass, although it's not done a whole lot of good so far. We had also have been able to bring on, partly because of the Bloomberg sponsorship and partly because the blog has become more well-known over the years, we have phased out the Stanford and Harvard law students who'd been covering cases and replaced them with practicing lawyers and law professors who have expertise in particular fields. And so if you scroll down, you can see we have some who contribute on a regular basis, like Ronald Mann is a law professor at Columbia who used to work in the office of the Solicitor General arguing cases at the court, and he covers almost all of our bankruptcy, ERISA, tax, and securities cases. We had one recently that he was not able to cover because he was arguing it at the court. We have experts in immigration and in criminal law, and then we go out, if we don't have sort of somebody on staff, so to speak, to cover a case, we go out and find somebody who knows a lot about that particular issue and ask them to write for us. And so, not just the comprehensiveness of our coverage, but the quality has really gone up over the years. And then, consistent with our efforts to be a more journalistic enterprise, we not only don't promote our own cases anymore, but really sort of affirmatively shy away from promoting them. And we've, not only do we not cover any of the cases in which we're involved, but we don't let anyone cover any of the cases in which they're involved, either as a lawyer on behalf of one of the parties or as somebody who represents one of what we call the friends of the court, who file briefs in a case, usually to try and further persuade the court to vote for a particular outcome, sometimes by providing particular areas of expertise. Law professors who have an expertise in that subject matter will say, this is why we think that you should rule in such and such a way. So really the only sort of opinion pieces that we have on our site are these kinds of, when we have really big decisions like the McCutcheon decision, the same-sex marriage decision, we will run online symposia in which we pick out 6 or 8 people who have expertise in the field and try to balance it as evenly as possible, ask them to write about the decision when it comes down. And so Floyd Abrams is one of the best-known First Amendment lawyers in the he was willing to write for us on the McCutcheon decision after it came out.
Did you write in favor of the decision?
He was mostly he was in favor of the decision in the sense that he was criticizing the dissent and their view of the First Amendment. So you can think of what it is. So, but we try very hard actually not to have a viewpoint, and we will have people come to us and say, we'd really like to write a decision, to write an op-ed about such and such, and we say, no, sorry, we're not going to take it. And then over the years, we've also tried to make our primary audience continues to be lawyers and law students, but we have tried to make it more accessible to non-lawyers, and so we have a feature for law students that's written in terms that a lot of people can understand, even if they're not lawyers or law students. And then for the major cases, we also have what's known as a plain English column that tries to break down the decisions for lay people. So that's where we are right now. We have a journalist who isn't a lawyer. Lyle likes to say that the only time he's been to law school has been to teach classes there. We have a journalist who isn't a lawyer, and then we have a bunch of lawyers who were not trained as journalists covering the Supreme Court. And I think it's sort of interesting to think about the big picture. We started this blog in 2002, and it's sort of a chicken and an egg thing in the sense that the resources that mainstream media have been devoting to the Supreme Court have, for the most part, gone down. And so I think that is, sort of the nichification of news and the proliferation of all of the different resources. And so that I think to a certain extent we're in the right place at the right time, that we found this opportunity at a time when there was an opening for it. So we're able to provide, because we have the generous support of Bloomberg Law, sort of an endless source, an endless supply of news on the Supreme Court. We cover all of the major cases, and the New York Times, and all of the different Politico, Washington Post, Wall Street Journal. They all cover the big decisions and even some of the not so big decisions. But we try to cover all of the decisions, and we found that because our audience is primarily lawyers and law students, that there is a demand for all of the coverage of all of the cases. And just to give you an example, on Wednesday, the court actually issued two decisions. There was the McCutcheon decision, and then there was another decision called Northwest versus Ginsburg, in which a rabbi was challenging Northwest's decision to drop him from its frequent flyer program after he made something like 24 complaints during a 2-year period and got several $1,000s worth of vouchers. And we were slow to cover that because Ronald Mann, the law professor who covered that case for us, had argued a case at the court that same day, and so he was catching up on all of his obligations. But we got several emails saying, well, where is your coverage of Northwest versus Ginsburg? We've been waiting for it, because there is an audience out there for almost every case, no matter how sort of narrow the decision is. And the way that people cover the news has also changed over the years, and this is a story that Adam Liptak tells when he talks about the difference between covering the court for the New York Times now and when Linda Greenhouse covered the court, especially in the 80s and 90s. The decisions were not available online, and so Linda would get the decision from the court at 10 o'clock, and she would sit there in the courtroom and listen to the court announce it. And then she'd go back to her desk in the press room and she would read the decision, and then maybe they'd all go out to lunch, all of the reporters, and they'd talk about it for a while, and then she'd go back to her desk and she'd write her story and she'd hand it in at 6 and she'd go home, and then it would show up on all of our doorsteps, in the form of the article in the New York Times the next day, and that was really the first reporting on a particular case.
Can I stop you for a second?
Yes.
I will just tell you, because she spoke to a couple of our groups. One of the things that they did when they maybe went out to lunch and talked about it was compared all of their notes on the quotes.
Yes.
So that they would all have the quotes in exactly the same way, because they didn't have access to a recording that soon at that point. Even the recordings came out much later, audio recordings.
Oh, yes, yes.
So the reporters really, worked together to make sure that nobody was going to look wrong and that they all had it as right as it could possibly be.
Right,
So, yeah.
right. And here, I am not in the press room, but, my understanding is that when they, leave an oral argument and they've got to go write about it and they've got to at least post their first take on the oral argument within an hour, they can have quick conversations as they're walking down the stairs to get back to the press office. But that's about it. And another way in which it's changed, is that the opinions are released and Lyle is not in the courtroom when the opinions are announced. And so when the healthcare is announced, he got the decision and brought it back to we were all operating from the cafeteria at that point at the Supreme Court, brought it back to the cafeteria and, trying to get out online as quickly as possible. A lot of the reporters, Adam Liptak, Nina Totenberg of NPR, still do sit in the courtroom and listen to the announcement of the decision. And that can take a really long time. I mean, the Chief Justice, when he was announcing the decision in the healthcare case, had this long discussion in his summary of the decision about why this was invalid under the Commerce Clause of the Constitution before he moved on to the part about how it was still valid because it was a tax. And so if you're sitting there in the courtroom listening for 10 minutes and outside all hell is breaking loose as people try to report it, and some people get it right and some people get it wrong, but they still hadn't gotten to the money line at that point in the courtroom. And so we actually now, to try and triangulate, we have Lyle in the press room and he gets the decision and brings it back to us as soon as possible. And then we have another contributor, Mark Walsh, who also writes for the ABA Journal and Education Week, who does sit in the courtroom and will later on then post something that's sort of a color piece about what was going on in the courtroom at the time, who was there, how did, that Justice Breyer, when he, stuff that doesn't show up in the decision, in the announcement in the campaign finance case last week, at one point, the Chief Justice in his summary of his opinion refers to Justice Breyer's dissent that was joined by the 3 other justices as a thoughtful dissent. And then, Justice Breyer sort of returns the favor when he's announcing his dissent. He says, it's a good opinion, I just don't agree with it. And so, that kind of dynamic is something that's really interesting to know, but you're not going to get it if you're not in the courtroom. And the flip side of that is that it's going to take forever to get the decision out if you're in the courtroom. So that's sort of the blog and how we operate. I'm going to then shift over a little bit to talk about from how we cover the court to covering the court more generally. And I know you're going to get more on this at lunchtime. But I think of this as sort of like, I love my job. It's sort of the best of beats in some ways, to borrow from Charles Dickens, and then the worst of beats in other ways. It is, in some ways, the court is extremely transparent. All of the briefs that are filed are a matter of public record. We have them online, but even if they weren't online, you could go down to the Supreme Court and copy them yourselves. The oral arguments are open to the public. You may need to get in line a week ahead of time if you don't have a press pass or a reservation, but you can go get in line, or if you're Rob Reiner, you can pay somebody to get in line for you a week ahead of time, so that you have a seat in the same-sex marriage cases. The decisions, with rare exceptions, are almost always based just on the briefs and the oral arguments. The justices will tell you that the oral arguments are rarely dispositive in their decisions, but if you go to the oral arguments and you listen, you can usually get a pretty good sense of where they're heading after an hour of oral argument. It's a very manageable beat. They have 80 cases a year that they spread out between October and the end of April, and then they spend the months of May and June issuing decisions. There are only 9 justices. You've got a very small universe of personalities to cover, and they're the only ones that are supposed to be making news out of the Supreme Court. You don't need to worry. The clerk's office, very helpful and very nice, but they're not going to give you any information. The clerks themselves are certainly not going to give you information, and so it's a beat that you can cover by going in. You read the briefs. If you have questions, you talk to the lawyers. You go to the oral arguments. You get the decision, and you write about it. It's a very predictable beat. We know that at 9:30 this morning, in 2 minutes or whatever, the Supreme Court is going to issue orders. We know when they're going to issue decisions. We don't know what decisions they're going to issue, but they don't just, at noon on a Wednesday say, okay, here's our decision in the McCutcheon case. We knew that they were going to issue decisions on Wednesday at 10 o'clock, and so we were there, and we were, more or less ready for that decision. And it is... it's a great beat to cover in the sense that there's an incredibly high level of briefing and oral argument at the court. The oral arguments are increasingly dominated by a group of about 50 lawyers or so, and so that you're going to get a high-quality argument almost every time, even if the lawyer who's handled the case in the lower courts rather than a Supreme Court specialist argues the case. The odds are very good that a Supreme Court specialist has helped a lot in the briefing. And so you're going to be able to read the briefs and, for the most part, understand what the cases are about. The oral arguments are fantastic, no matter how boring the subject matter is. ERISA, intellectual property, tax, the justices are going to make it interesting. They come incredibly well prepared to the oral argument. They're engaged. They're asking questions. There are lower courts. My husband once did an argument in one of the federal courts of appeals. It was what's known as an en banc, which meant that they'd lost in the 3-judge panel stage and moved on to all 12. He got up there for 15 minutes and nobody asked him a question. That does not happen at the Supreme Court. It used to happen. If you ever go have a chance and you're really bored, you want to go back and listen to some of the old oral arguments. Like you listen to Justice Ginsburg when she was an advocate. They let her talk for 10 or 15 minutes at a time, just sort of elaborating on her case. So that was the best. That's the best of. And the worst of is that the court is more transparent than it used to be. When I first started doing this, the transcripts did not identify the justices by name in terms of who asked a question. It just said justice or, question. And so as a very junior lawyer, if somebody else in our firm was arguing a case, one of my jobs would be to write down who asked what question so that then you could go back and annotate the transcript and sort of track who might be with you, who might be against you. We now get oral argument at the end of the week. That's a big improvement over when I first started doing this. No, the audio. The audio. It comes on Friday. So the arguments are usually Monday through Wednesday. The audio comes on Friday afternoons. Which is both a good thing and a bad thing. It's nice to have the audio that soon. The flip side of that is it comes too late to be useful when you're actually writing your story about the case 2 hours after it happens. And they have, I think for the most part, sort of used the fact that they give us the audio at the end of the week every single time as a reason not to hand out, to release the audio immediately after the oral argument. That the theory is that every case the Supreme Court is an important one, and if you release the audio sooner, you're sort of singling out some cases as being more important than others. So the court is still not very transparent. The court makes its decisions at the private conferences of the justices, and it's just the 9 of them in there. They don't have any clerks, they don't have any support staff, and so you get the decisions when you have opinions, but you don't know the rationale. There are many cases in which they're not required to explain themselves, and they don't. And so if a justice is recused from a case, he or she doesn't participate, the docket for that case will note that Justice Kagan took no part in this case. With Justice Kagan, it's usually a sure bet that she was involved in the case as the Solicitor General. But if it's anybody else, if it's Justice Breyer, you don't know whether he's recused because his brother was the lower court judge or because his wife has stock in the company. You can go and try and triangulate and figure out why they might be recused, but they don't say why they're recused. They don't have to. They don't have to say why they don't grant review in a particular case for 99.9% of the time. They just issue an order that says, certiorari review is denied, and you don't know why they decided not to take a particular case. If they don't act on a particular case for long stretches of time, you don't know why they're not acting on that case. Again, you can try and guess. Is it because they are waiting to see, how they're going to vote and then issue a decision in a related case? Is it because, so there's one case, a criminal case out of Arizona that has been sitting around on the court's docket since October, and they just keep sort of putting it on their conference again but not acting on it, and we don't know why that is, and eventually we'll figure out, but they're not under any requirement to explain why they're not acting. The justices give speeches, they travel all over the country, but they, for the most part, they don't. The Public Information Office does not, and I should say that the speeches can sometimes be. They don't comment on pending cases. They don't comment on cases that might come before them, and they generally don't comment on cases after they've been decided. So in that sense, they're not particularly illuminative, but they also, just sort of help you to get a better sense of what, sort of how the justices think. And so the Justice Sotomayor recently has talked about how, her experience as a prosecutor, perhaps makes her look differently at criminal cases than some of the other justices. And Justice Alito was a U.S. attorney, and she said, well, that's different because he was in the federal system. The federal system tends to operate a lot more smoothly. And so it does give you some insight, but the PIO doesn't announce in advance, where they're going to be. And so, you have to sort of, to a certain extent, get lucky and figure out in advance that they're going to speak in a particular case. And so there was a scenario earlier this winter, I think, in which the court was announcing decisions, and the Chief Justice announced a decision for Justice Sotomayor because she wasn't at the court. We didn't know where she was until you start Googling around and you realize she's supposed to speak that night in California. But nobody really discloses that in advance. The justices can also wield a fair amount of control over their public appearances. If they want to have it be no video, no audio, that's the way it's going to be. It's relatively.
And is that still true? I mean, certainly political candidates would like to be able to gather donors and say no video, no audio, but it never really works out that way.
No, I
think this stuff?
people. I think for the most part, if they say no video or no audio, it's relatively rare for it to then leak out. I mean, that's sort of a whole new can of worms with.
And if it did leak out, would you guys use it?
Yeah, I think we probably would. I mean, you know,
If it was out there.
if it was out there, we haven't really had to deal with that situation yet because it hasn't happened.
Didn't something like that though just happen and at a university, one of the male
Justices maybe.
and someone got video of it or a photo maybe and
Mhm.
tweeted the words that they said, and then I heard it on NPR. They were just saying, once it was out there, then everyone wanted to put it
Right,
out there, so
right.
everyone did. And how much control do you have now?
Exactly. I mean, that's the thing.
He's
Is
not speaking at that university.
exactly. I mean, I think in this day and age, with everybody with the something as innocuous as cell phones with video cameras, it's you can try, and certainly the quality of the video or the audio is going to be poor, but I think they have to recognize that it's probably going to get out there.
Well,
So-
it's absurd anyway for justice to feel like they can go to our university and speak privately to 3,000 people.
To 3,000 of their closest friends, exactly. And then, of course, my biggest bugaboo is that there are no cameras in the courtroom. As I said, the audio used to take forever. Now it's available on Fridays, at which point it's really too late to be useful. And yes, you can go and stand in line and try to get one of the 50 seats, but that's not always the easiest thing to do, even if you have a fair amount of time available, which most people don't, and you happen to be in Washington D.C. So we can talk all you want after this about cameras in the courtroom. So I think just a couple of things in closing. For better or for worse, covering the court is not. I'm just going to refresh and see what happened. Yeah, see Dullsville or Cherokee Basin. It's not an entrepreneurial beat for the most part. Unless you are Jan Crawford, the leak about the Chief Justice having switched his vote in healthcare. I mean, there are not a lot of stories like that come out of the Supreme Court. I remember listening to reading one of the political reporters for the Post after the healthcare argument, and he was, said, I'll bet, I'm 100% convinced that someone will leak the result of the decision before it comes out. And I'm thinking that would be, extraordinarily unlikely that they would release someone would leak the result before it came out. And nobody released it before. There was the discussion afterwards about whether or not he'd switched his vote that I think came from a very reliable source, and I think everyone believes that it's true. But a story like that is really an exception, and it's not. I mean, that is a story that it's not something that you can just kind of work your contacts and hope that somebody agrees after you badger them enough to give to you. I mean, that is a story that somebody decided to give to her. So it's not an entrepreneurial beat. I mean, Adam Liptak has complained that if you've got, the story on McCutcheon the day after the oral argument, that you can line basically everybody's report on the oral arguments or on the decision up, and it's going to look basically exactly the same. I mean, you've got kind of a limited amount of material to work with. The other thing about covering the court is that you want to pay attention to the narrative. I mean, the big cases that everyone pays attention to are the ones that people think of as likely to be 5-4. You've got the 4 more liberal justices, the 4 more conservative justices. You've got Justice Kennedy in the middle, and how is he going to vote, and that's going to decide the case. And so I don't want to downplay that, because that certainly is the way, McCutcheon, for example, played out. But you don't have to look any further than the Proposition 8 case last term, the challenge to California's ban on same-sex marriage, in which the decision was 5-4, but it was the Chief Justice, Justice Scalia, and Justices Breyer, Ginsburg, and Kagan voting that the state official, that the proponents of the initiative didn't have a right to be in court to defend it. And then you had an even more bizarre group of Justice Kennedy, Thomas, Alito, and Sotomayor, all voting together to agree that they did have a right to defend the initiative, and the court should have gone ahead and considered the merits of the case. And so, the overwhelming majority of the court's cases are not 5-4 or even 6-3. They're 9-0 or 8-1, because the court takes cases like that. I don't even know what that case is about, but it's not going to be a headliner when it happens. And there are close cases in which the justices don't divide on traditional ideological lines. Back when I was still involved in the litigation clinic at Stanford, the director of the clinic, Jeff Fisher, who does a lot of criminal cases, argued a capital case out of Alabama, and he came out of the oral argument. He was despondent because he had clearly lost Justice Kennedy and was pretty sure that he lost Justice Ginsburg too. And if you don't have either one of those on your side in a capital case, you're screwed. But turns out that he did lose both of those, but he won the case because he got Justices Scalia and Thomas to join, I guess this was a while ago, so it would have been Breyer, Souter, and Stevens to vote for his client. So, you can't always just think of it as sort of 5-4, locked in mortal combat for the vote of Justice Kennedy. So the takeaway is, you pay attention to the narrative, but you also just need to do your homework, read the briefs, and go to the oral argument. So that's what I've got. We still have 35 minutes for questions. Hopefully you'll have some.
What do you think would happen if there were cameras in the court? I mean, obviously some of the justices play toward when the press is in there anyway. Do you think it would be more so if the cameras were there?
Yeah, I'm kind of a hardliner in this. I do not think there was a single good reason not to have cameras in the courtroom. The most compelling reason that I've heard is one that came up recently after there was the Citizens United protester, which was the idea that if you have cameras in the courtroom, people are going to sneak into the courtroom and then cause a disruption to draw attention to a particular cause. I think that's the case wherever you've got like State of the Union or anything else where there's a high profile event and cameras. I think all of the other arguments are excuses. I mean, the idea, and Justice Scalia, I know, has said it, others have, this idea that we shouldn't have cameras in the courtroom. Sorry, I get a little worked up about this, because the justices themselves might start playing to the camera is just, unthinkable to me. I think that's their problem, and they need to deal with it. There's already some fabulous one-liners that come out, and maybe they will. But I don't think it would detract from the overall oral argument experience. I just don't think it's a good reason not to. I think that, as I said, it would show them as being, the most functional branch of government by far. I mean, they're 9 really, really smart people who come incredibly well prepared to every oral argument, even, Dark Cherokee Basin versus Owens. They ask great questions. The lawyers are quite good. Another argument that I've heard against cameras in the courtroom is the idea that be these sort of Johnny Cochran moments that they're going to have lawyers pandering to the cameras. I think that most of the lawyers who argue there are regulars. They're not going to risk their reputation by trying to come out with these sort of non sequitur one-liners, because they ask you a question, they want to hear the answer. They don't want to hear if the shoe fits, if the glove fits, you must acquit. And only the really good lawyers are going to be able to sort of be responsive to the court's questions and work in the sound bites, and they're not going to do it. So.
Oh yeah, I have a question. Kind of a two-part question. One is just about the blog.
Uh-huh.
Was it ever going to make money before you got the Bloomberg law?
Oh no.
So in terms of a sort of a startup, it wasn't something that...
It was a loss leader for a very long time.
And the other question was more about the Supreme Court in general. Your blog typifies this in a great way. There's lots of information about the most important stuff, the decisions, the law,
right.
But almost no information about the institution itself, like behind the curtain. The way they work, who gets to work early, who
right.
stays late, who is grumpy and who's not. I mean, that comes out in books occasionally,
right.
But so how much, if you look at the, say, major media that do devote a little bit of time to the Supreme Court, that never gets in there. So the average reader knows nothing about these people who have enormous, or very little about these people who have enormous influence.
No, I think that's right. I think, most of what we know about them as people, comes from their confirmation hearings and then their public appearances. Part of it is that, the people who would know these things don't speak in public, the clerk's office and then the clerks. And, there's really even a fair amount of stigma to the clerks speaking out after they leave. They're not supposed to sort of disclose almost anything that happened on their watch. There was a book, gosh, it's been a while now. It was maybe the mid to late 90s, a clerk did publish a book, sort of an expose of how divided the Rehnquist court was at the time, and he's been ostracized, in the sort of Supreme Court community for doing that. So yeah, so I mean the blog of Legal Times, Tony Morrow does a good job, with some of the sort of more sort of human interest stories, but there's just not a lot of them coming out.
If we just looked at Congress and said the only thing that matters is the legislation, because they're august lawmakers and senators, and we're not going to worry about anything other than their debates on the floor and the legislation they pass. And I think that would be really bad coverage of Congress. And I just want,
Right.
Obviously, it's not weaknesses in the reporter, but the institution's set up differently.
Right. No, and I think it is. As sort of the anecdote about Justice Sotomayor and sort of her views on how her work as a prosecutor affects her votes in criminal cases. This came up. It was a really marvelous interview that Linda Greenhouse did with her at Yale. I know that the transcript, I don't know that there is an audio or a video of it, but the transcript is available online through the Yale Law Journal, and I thought Linda asked great questions, and there were really good answers, because she was asking her about an opinion that she'd written dissenting from the court's decision not to hear a particular criminal case, and she sort of explained how she, her role as a prosecutor influenced sort of her view of the state criminal system. So, but yes.
I am wondering, when did you realize that people were looking at SCOTUS blog as like the go-to for Supreme Court news? I remember when I was watching CNN announcing the wrong verdict, and they were like, wait, hang on, SCOTUS blog is reporting this. And I was thinking, like, I wonder if SCOTUS blog feels awesome right now that, like, people out that way. Because, a bunch of news organizations are reporting different things, but CNN stopped and was like, okay, SCOTUS blog is saying this, so we need to look.
I think that probably really was sort of a watershed. I mean, in 2008, the court had a big decision, the first big Second Amendment decision, D.C. versus Heller, where they said, there's a Second Amendment right to have a handgun in your home. And we got 100,000 hits that day, and we were really excited about it. So it's been, our readership has increased pretty sharply. I mean, to go from that, to the point at which we were, before the healthcare decision, we spent a lot of money trying to ramp up just to make sure that we wouldn't crash that day, and we didn't. But there is sort of very much, you do feel like we're in a little bit of an echo chamber. Like, it still sort of surprises me when that people read the blog. Okay, so yes.
Here, I've always sort of been fascinated by how technologically backward the federal courts are.
Yes.
Overall.
Yes.
My boy worked for a federal judge, and he would literally cut and paste his edits like with scissors and paste. And do it
Right.
like
Right.
And I've known some other people.
I think Justice Souter used to do that too,
And
just for what it's worth.
I was kind of curious how sort of with the press corps that covers the Supreme Court, like, I don't know, I guess in a given year, like how much you press to, to make the court more technologically advanced, and sort of how those negotiations go, or if it's just a matter of, well, Chief Justice says we can't do it, so we can't do it.
I mean, the court has, to give credit where credit is due, has come a long ways under the current Chief Justice. I mean, think the release of the audio, the same week release of the audio. The court now releases decisions online much faster than it used to. On a day like healthcare, whether or not the court then, whether the court's website is supposed to stay, it's obviously supposed to work when you've got several million people going to it. It doesn't always do that. I think that there is sort of a give and take. I mean, there are certainly requests made every year for same-day release of audio in the big cases, for, can you think about cameras in the courtroom? I think that everybody feels like it's a process, that it's not something we're going to get overnight, but if we keep asking, hopefully we'll get there eventually. Yes.
Do you have any tips on reading the briefs? Because I feel like sometimes when I'm reading these briefs, you're like, oh my gosh, I did not go to law school.
Right,
I have
right.
no earthly clue what, you know, 'cause some of the language is very.
Is very, yes. Okay, so I do have tips. I mean, the biggest tip I have is that if the United States is involved in the case, to read their brief first. They are rarely an unbiased party, but because the Solicitor General's office is at the court so often, they really are pretty straight shooters. And so they can use, and they're, 14 very, very good lawyers who've all practiced before the Supreme Court, usually for quite a while. And so it's going to be very, very accurate and very well written and a pretty objective representation. In the briefs on the merits, the summaries of arguments can usually, tell you most of what you need to know about a case. I mean, you're not going to necessarily get into the nitty-gritty of this case or that case and what it stands for when you're covering it. So the summaries of arguments can be good. And then the other thing, sort of depending on how many there are, that the friends of the court briefs sometimes can be quite useful. And they too are supposed to have summaries of arguments in trying to figure out whether or not a case is as important as the parties make it out to be. Is this really something that's going to result in millions of prisoners going free, or is the impact in fact a little bit more limited? So, yes.
Oh, I just have a question about when decisions come out.
Mm-hmm.
How do you know when they're going to come out?
They tell the press on Friday, and it actually goes out on this is again sort of a technological thing. It doesn't go on the court's website, but it does go on a telephone line that you can call and hear about what's happening at the court the following week.
Really?
Yes.
Can you get that number?
I could probably find it for you when we're done. But so the court does announce, but in my own self-interest, I will say that it'll be on the blog. That usually what happens is that at some point on Fridays they will tell the press corps sort of as guidance so that they can plan their following weeks accordingly, and then it will become official later on that day. And as soon as we know that it's official, we will put it up on the blog every single week.
But on a really big cases, you're still waiting day to day.
You are still waiting, unless it is the absolute last day of the term. Yes, you don't know on any particular day what decision you're going to get.
The term.
Is at the end of June.
Okay, because I'm following a couple of Michigan cases that
Uh-huh.
I went to oral arguments.
Like the
last year.
shooty one, or
Yeah.
Who knows if we're gonna get that.
I'm just wondering, getting
Right.
tips,
I mean that's the shooty one. This is the challenge to Michigan's ban in the Constitution on the use of affirmative action at public universities, and it was argued in October. And that's one like McCutcheon where we could get it the next time they announce decisions, and it wouldn't surprise me. Or we could get it at the end of June, and that wouldn't surprise me either. I mean, last term, you just don't know what's going on. Last term, when they had the Texas affirmative action case, it was argued in October, and we got it the last week of June. So
So they wouldn't have that on the Friday phone call?
no, because frequently, they have this tradition that, if you are writing one of either the opinion or like a dissent or concurring opinion, everybody has to sign off and say, okay, we're ready to go, before they release it. And so, I think sometimes what happens is that they will announce on Friday, and they will give the press corps, sort of a rough range of we're going to have, I say, a light day, which means like one or two opinions, a regular day, which means anywhere between 1 and 4 opinions, or a heavy day. But, they may not know themselves on Friday for sure which opinions are going to be released the following week. Okay. Next.
How much do you think, how long will it take for them to kind of advance on this, making things more public? Is it do you think there's certain justices who have been there a while and are reluctant to change, and once they leave it'll be better, or?
No, I don't. I mean, it used to be that the Justice Souter, when he was around, was the one who said, they're going to roll the cameras into the courtroom over my dead body. Well, he's been gone for several years now, and Justice Sotomayor and Justice Kagan, both in the confirmation hearing, said, I think that's something that I might be open to. I'd have to talk to my colleagues about it once I'm on the bench. Boom, Well, there are a lot of reasons. There are a lot of good reasons why we don't want to have cameras in the courtroom. I think I don't know what it's going to take to get cameras in the courtroom. You know, I know you're not just talking about cameras, but I mean, I think the one thing that a lot of people talk about is the sort of Jon Stewart, Stephen Colbert factor, that you know, nobody likes to be on TV being made fun of, and you know, if you have the video, it's much more likely to happen. I think is a big reason. I mean, sort of the other technological change. I mean, the cameras in the courtroom is the big one. You know.
Although Jon Stewart's managed to do a really good job of making
Right.
fun of them without
With
having to
exact,
send
yeah,
them
no,
back.
there is
Everybody
that.
see his piece on the Hutchin decision, in which, because there are no cameras in the courtroom, he said we had to have, you know, our artist present, and so the artist presented a picture of the judges on the bench with like 4 hookah pipes. So they all smoking. You know, I mean, it was really funny, and it was right on target. It was deadly humor, which not unusual for him, but
Right.
yeah. So I would think it would be almost better to have actual
Right.
video.
Yes.
Has there been a particular case or your top 2 cases that brought the most readers to your Scribble Live sessions?
Yes, I mean the healthcare, hands down, was the biggest. We had on our what we call the live blog 1 million readers at once, and we had then about 5 million over the course of the day. The same-sex marriage cases were, you know, we still had a lot of people, but it didn't come close to that. I don't know whether, you know, I guess I would have thought it would be as big, but you know, I guess sort of the healthcare, the individual mandate, it was, you know, this sort of perfect storm that you had the president's signature legislative accomplishment during the middle of a presidential campaign. I also think with the same-sex marriage cases, I mean, there was still some uncertainty about what they were going to do, but it seemed pretty clear after the oral argument, you know, sort of where those cases were headed, and so there wasn't the suspense that there was with the individual mandate. So those were probably the 2 biggest drivers. Definitely. Yes.
What are, you mentioned the Michigan affirmative action, what are some of the other big cases expecting before the end of
Sure.
decisions?
Okay, so Schuette versus Coalition to Defend Affirmative Action. The Michigan affirmative action, we have Town of Greece versus Galloway, which is whether or not this small town in upstate New York can start its town council meetings with a prayer. The NLRB versus Noel Canning, which is the challenge to the president's recess appointments power. Then there was the birth control mandate, which was 2 weeks ago, I think. At the end, Hobby Lobby, exactly. Hobby Lobby, which was argued at the end of March. And then in April, there's still a couple of big cases, not as big, but still big. There's a case called ABC versus Area, which is about the streaming of broadcast TV over the internet. And then the last 2 are really interesting ones. They're not like Hobby Lobby level, but they are basically, if the police arrest you, can they take your cell phone and look at all of the contents of your cell phone and then use what they find on your cell phone against you? So, you know, and this is, again, returns to the question of technology. You know, how are the justices going to deal with these issues that, you know, I think are, to put it mildly, not their forte.
Is
Yeah.
that,
Oh, sorry. Good. Yes.
I don't know how transparent the decision-making process is.
Not
at all.
at all.
So do you have a sense of, you know, after arguments and everything is done, do they just go, you know, their 9 separate ways and then each vote, or is there any kind of debating, haggling, negotiating over the way that a final opinion is going to look?
Sure. That's a great question. So after the oral arguments, they go back usually on like pretty within either the same day as the oral argument or within a day or 2, and they have their little meeting of the 9 of them, and they vote. And they start with the Chief Justice, and he votes, and then they go around the table in order of seniority. So Justice Scalia, Justice Kennedy, Justice Ginsburg, and they vote. And so then the way it works is that the most senior justice in the majority, and the Chief Justice is always the most senior, even though he hasn't been there the longest, and then the senior justice in the dissent get to assign the authors of those opinions. And so that can be sort of strategic. You know, you may, you are the Chief Justice and you've got Justice Kennedy, just to use an example, and you want to make sure he stays on board, you may assign him to write the decision in your case, to sort of keep him and let him sort of tailor it. You're going to be able to keep, if it's something like Justice Scalia on board no matter what. But if you think like Justice Kennedy might be wavering, then and then the same thing happens with the dissent. I don't know, so Justice Ginsburg, and this is one of the reasons that people cite as a reason why she's unlikely to retire anytime soon. Justice Ginsburg, if it divides on sort of 5-4 ideological grounds, is automatically the senior justice in the dissent. And so she can decide, do I want to keep this for myself? Do I want to give it, as in McCutcheon, to Steve Breyer and let him write? And so she wrote, has written some of the big dissents over the last couple of years. And then they go back to their chambers and they start writing. And when the author of the majority has a draft, he'll send it out to all 9 justices, not just the people who said they were on board. And they write back, they can say, well, I agree with everything you said there, and it's called please join me, which means I join your decision. And sometimes they may suggest big changes, sometimes they may suggest very small changes. And then the author of the dissent does the same thing. And they can respond, they can then tweak the opinions to respond to what the other side says. People can write their own separate opinions, as Justice Thomas did in the McCutcheon case. He says, I agree that the aggregate limits should be struck down. I would go even further and overrule this 1976 case, which would basically get rid of all limits, not just the aggregate limits. And then at the point that everybody feels happy with it, or it's the end of June, whichever comes first, then they release the decisions in the court. And so one of the things, like when you're talking about the justices at oral arguments, I've heard Justice Kagan say this, in a public speech, and this is why you go to these various speeches when you can find out about them, is that they don't, when they decide to review a case, they meet in their conference, and if at least 4 of them agree, they review a case like Dart Operating Company or whatever it is, Dart Basin. And then they don't actually talk about the cases much before the oral argument. The oral argument is really the first chance that they have in many cases to figure out where their colleagues are on the issue. And so Justice Kagan has said, I'm the junior justice. By the time they get to me, everybody else has already voted. And so if she's got something to say about the case, she's got to say it at the oral argument. She asks really terrific questions at the oral argument, but part of what she's doing is trying to, sort of not just ask the lawyer questions and get answers from him or her, but sort of make points, that may affect her colleagues' views of the cases as well.
But it sounds like when they do that initial vote, that pretty much sets the decision right there, like sets where it's going to be, and then they.
And people do switch sides sometimes. I mean, healthcare is probably the most dramatic example of it, but there are other. One of the things that you do when you track the Supreme Court obsessively is you look at the justices will hear. They divide up try and put it simply. They divide up their opinions, not only over the course of the year, so that everybody writes roughly the same number of majority opinions, but also over the course of what we call a sitting, which is like the 2-week stretch in October or November or December in which they hear oral arguments. And so sometimes, you'll look at the end of the year at who wrote what opinions in October, and you see that Justice Sotomayor didn't write a decision in October. And so from that, sometimes you can surmise, and this is really sort of inside baseball, like maybe she had a majority and then she lost it. So things do change. But also, a lot of the decisions are, 8-1 or 9-0 because they are these cases that are not high-profile cases that the justices take to resolve divisions in the lower court, so that the same federal law means the same thing all over the country. And so sometimes, you kind of get the sense that maybe somebody might have a slightly different view, but, we'll just, if it's, what's the difference between 8-1 and 9-0, we'll all go along to get along, kind of a thing. Yes?
You mentioned the kind of complaint that, after decisions, a lot of the stories come out with the same.
Yes.
But I've also noticed after, contentious arguments that most of the kind of takeaways and the kind of analysis of those look the same. Do you think that's just because everyone there is very smart, they're all on the same page and they know what they're doing? Or are you ever concerned about kind of like an echo chamber, like, you know?
Oh, sure.
I mean,
Yeah.
that everyone, you know, if you're the reporter who writes a story that, you know, maybe it's not this clear 5 to 4 based on the oral, I mean, everyone is at the same hour-long argument.
Right.
So what do you kind of make of that?
Yeah, I mean, I think that, these are all people who've been, for the most part, have been covering the court. I mean, people like Adam Liptak, everybody thinks is still kind of the new guy on the beat, even though he's been there now for like 7 years. Nina Totenberg and Lyle and David Savage of the LA Times have all been there for decades. But there is, and on the margins, I think, but on the one hand, you want to get it right, most importantly for your readers. But on the other hand, you don't want to be the one saying, oh my gosh, the federal government is absolutely positively going to win in Hobby Lobby, when everybody else is saying that the federal government's probably going to lose in Hobby Lobby, and it's just a question of how, or McCutcheon, with the aggregate limits. So I do think there is also sort of, for better or for worse, at least a little bit of an echo chamber. Yes.
And another business question. So you guys do this as a public service? Is it a profitable blog, or is it just kind of you get grants to cover your costs?
We get when you run the numbers, everything that Bloomberg gives us basically goes into the blog. I mean, but that includes my salary. We're not profiting off of it as such. And we usually roll the money back into the blog, either through technology and law students and paying honoraria. So it's not profit, but it pays Lyle, it pays me, it pays Callie, our blog manager, and it pays for our servers, that kind of thing.
Do you pay law students?
We only have one law student now, and she does get paid on an hourly basis.
How does Tom handle sort of the Supreme Court practice and then this?
Yeah.
Because I think the really interesting evolution is it started out as, like, as you said, a business development tool, marketing tool, and then it became something people rely on to be a source of journalism.
Mm-hmm.
And it's still connected to a guy who makes his living, obviously.
Right.
On arguing his cases. So how does that get balanced, and is that maybe why you've had trouble getting a credential?
That is exactly, I think, these days why we're having trouble getting a credential. I think that I think that there are two things going on. I think that is probably the biggest one. And then I think the other thing is just that the Supreme Court, that is trying to figure out. I think that if they could make a rule that gives SCOTUS blog a press pass, I actually think that they would. But the question is how to draft a rule that gives SCOTUS blog a press pass without giving every other blog, because it doesn't take a lot to start a blog. You go onto WordPress and you set up an account for free, and voila, I think my 11-year-old has a blog. She doesn't update it, but she has one because it's that easy and it's free. And how do you set a rule that gives SCOTUS blog a press pass, but not every other blog in the world? But I mean, I think his role is a big problem, and so we've really tried, especially in the last couple of years, to put safeguards into place. We don't cover our own cases. It used to be that Lyle would cover some of Tom's cases, and Lyle tends to be quite critical of Tom's performance, perhaps to demonstrate his independence. But Lyle doesn't even cover Tom's cases anymore, and it really is much, as the publisher, he is not very involved in the day-to-day operation of the blog. He's much more the 10,000 feet guy. I think we should redesign the blog, but it's still, it's a problem. I mean, the real sort of catch-22, there was a flurry of stories about why we don't have a press pass probably around this time last year, and somebody from the New York Times wrote an op-ed that said, well, there's an easy solution. He should step down as the publisher. And I think that would eliminate a lot of our problems. It would also eliminate a lot of our funding from Bloomberg Law, I think, to be totally honest, because he's a big part of the draw. I mean, I like to think that Lyle and I do a good job, but I don't think that Bloomberg would be willing to fund us at the same level. And I don't blame them. So
It's interesting.
it's interesting. We continue to grapple with it, and we try to do as much as we can to sort of maintain the blog's editorial independence from the firm. But at the end of the day, he's on the masthead, and he's the the managing partner of the firm.
Right.
Do you have a contingency plan though for when Lyle finally steps away?
Lyle's never going to retire. Really. I mean, Lyle has more energy than I do. It is not unusual for me to go to bed very late at night and get up the next morning and find out that Lyle has something else in the hopper that he did. There was a Guantanamo decision at 11:30 last night. So, yes.
Do you feel like you have any real competitors in this space with the same amount of information and focus, or do you guys kind of have your own?
I think we kind of were lucky enough to get there first. I mean, I think there's a lot of great coverage out there, but that nobody else sort of has found somebody who's willing to devote the resources the way Bloomberg Law has with us. So, yes.
I've been seeing these commercials about getting cameras in the Supreme Court courtroom.
Uh-huh.
And I'm just curious, like, who is spearheading the effort, and are you guys part of that? And do you know why it's sort of coming to a head at this moment now?
I think that we are not part of it. It is, I think, led by, there's a group, I can't remember the name of it, but that's pressing for more transparency in the court. I think part of it is that there have been, 3 years in a row now, these really high-profile cases in which there's been a lot of interest and no television coverage. I was laughing because after the Hobby Lobby argument, there was some congressman who couldn't get into the oral argument and is now a big fan of cameras in the courtroom. So I think it's sort of a confluence of circumstances. I think that, I've been doing this long enough to know that like every couple of years it sort of pops up as an issue, but I think especially because it's been, it's for whatever reason, there's been this stretch of really high profile arguments. I think I think that the CNN Fox snafu probably also added to it. I mean, if everybody got to watch, that it would have taken a while, but everybody would have eventually figured out what was going on.
Final question, anybody? Okay, well, thank you so
Oh,
much.
sure, it was fun.
This
That was a great question.
Really appreciate you being here.